founder and managing partner of the firm's Mumbai office. She heads the firm's international litigation and ADR group. Ms. Setna has 33 years of litigation and arbitration experience handling complex work across multiple jurisdictions in diverse industries. Her global reach of work spans the United States of America, the UK, Europe, Singapore, UAE, Australia, Canada, Indonesia, Africa, Oman, and other countries. Across oil and gas to infrastructure, banking and finance to transportation, real estate, mining, energy, metallurgical, information technology, telecom, communications, hospitality, etc. She advises and represents global conglomerates, prominent Indian business houses, industrialists, sovereign government in a wide gamut of cross-border work, often as a key driver in international litigation teams in association with prominent international law firms, international counsel, global investment and business advisors. Ms. Setna exercises rights of audience across courts, tribunals and adjudicatory authorities in India, arbitral and conciliation bodies internationally. In India, she appears in the Supreme Court of India at New Delhi, across High Courts of Bombay, Bangalore, Calcutta, Chennai, Cochin, Delhi, Ahmedabad, Bhubaneswar, Hyderabad, district courts across India, special central bureau of investigation courts, magistrates, and session courts across India. I request Asad sir to felicitate and present a token of appreciation to Farishta ma'am. Thank you, ma'am. Thank you so much. With this, I now hand over the stage to Ms. Tenille Flaherty. Request her to proceed with the session. No problem.
So I'm going to start by giving you again a brief introduction to Peter. So Peter obtained his Bachelor of Economics in 2000 and a first-class honours degree in law from the University of Adelaide in 2003. He was admitted to practice in September of that year and joined the South Australian Bar in December of 2014. Since February of 2015, Peter has been practicing as an independent barrister at Murray Chambers, acting in a wide variety of civil matters in all jurisdictions. The bulk of his practice involves commercial litigation, property disputes and deceased estates. He has also acted in environmental and planning matters, personal injury matters and administrative law cases. Peter has a special interest in defamation and has acted in a number of high-profile defamation cases during his time at the bar. And in preparation for giving you that information about Peter might have shown me what a chatbot said that he was most famous for, but I might leave that out because I can't substantiate that he was ever the Premier of South Australia. Anyway, or President of our Bar Association. Moving on. So Peter and Ms. Setna are going to talk today about drafting and presenting of legal argument. Peter's going to take you through a fairy tale story about the drafting and presentation of legal arguments. Now I say fairy tale because you want to be able to draw your audience in from the moment you start speaking, tell your story, and end with your prince or princess winning. Winning or convincing the court relies on both written and oral submissions. So I'll now let you be taken on that wonderful fairy tale journey by Peter, and he will go through your ability to present in a way that tells that fairy tale in the courtroom.
Once upon a time, there were 3 lawyers. They were all mean and they were all nasty. One day, they went for a walk in a tiger-infested forest. They were never seen again. And everyone else lived happily ever after. You're all storytellers. Good advocates are good storytellers. And this afternoon I'm going to tell you how to tell a story. Every story has a structure. Every story has actors or actresses, villains, victims, heroes. It takes place, this event, whatever it might be, somewhere. Things happen somehow. How do I describe my story? Well, let's start with what we do as advocates. The first story we need to identify is our client's story. What is their case? What is their case in law? How do I find out whether this man or woman, my client, this victim, has a claim or a right and some justiciable cause that a court will be interested in? By the time you've graduated, you'll know how to spot that in a heartbeat. But getting that story together requires some skills. You need to ask questions of your client. You need to find out what the facts of the case are. And as you build the story, you're then going to ascertain what law applies to my facts. What is the applicable legislation? Is there a common law component to it, or perhaps some international legal component? We learned something about that this morning. But the story that we're telling is based around those facts. The session just before this one was about eliciting the evidence upon which the facts will be found. Remember that you've got a decision maker sitting at the front. If there's a jury, they're often sitting alongside you. I'm telling my story to that decision maker. How do I help him or her or them decide the case in my client's favour? That's where we're headed with this story today. It's about preparation, it's about presentation, and it's about performance. And if you focus on those 3 aspects as you go into any case, you'll apply a self-discipline which is critical to legal practice. You're all gifted with keen analytical minds. People are naturally drawn to stories, and lawyers are naturally gifted at telling forensic stories. Who did it? Why did they do it? What happened? What should the result be from the event that occurred? So that's the starting point. What is my client's case? What is the story that I'm going to tell? As to the law helps and the law hurts. There will be a way of applying principle or a provision of an act of Parliament that works with you or against you. Part of your case might be simply directed at the application of a peculiar provision. What does section 2 mean? That might be the entire case, and in a case on appeal, that's often the only case, the only question that matters. What does the law say in that provision? What does it mean in its application? Don't run away from unhelpful provisions. You will have to address them. And I'll help you focus on how you address them in a moment. But rely on your own judgment, your own wisdom, your own experience, and what might be called the law of common sense. And we heard earlier this morning about the great history and development of Indian legal tradition dating back many, many centuries. And most of those laws and rules in their application, not their development, came about from common sense. The rub, the push, the pull of human life and human nature was a feature of both Verona's address this morning. Why do the rules develop? And when you come to argue about a provision of an Act of Parliament, yes, you might have assistance and guidance from speeches in Parliament about what the Parliament, the legislators meant by a provision. And quite often, you'll be on your feet and ask, well, what does it actually mean? But what about this? What happens if we apply it in this way? And you might resort to common sense if there's nothing else. Stick with that. And your argument is something that will develop. Think about it like a child. Think about it that you're the parent of that child and you want it to grow and develop and be disciplined, well-mannered, sensible, that can be presented into the world without embarrassment. That's your argument. Is it a good argument? Test it with your friends. Test it with colleagues. And if there's a hole in it, and this is one wonderful thing about the profession, your colleagues will soon tell you when you are wrong. They will not hesitate. And that's particularly so at the bar. You've worked out what your client's case is. You understand what the law should be or how it might apply in your case. What do you want the judge to do? What is the remedy, the order, the relief that you're seeking? Early in my career, I made a habit of watching judges in action. I saw a junior solicitor attend upon a hearing in the district court in Adelaide. And the young man was flustered, he didn't have his proper robes, he came into court in his lounge suit and tie, and was very embarrassed and apologetic, and spent 5 minutes going on about his attire. The judge wasn't particularly interested in that. And after a long-winded exposition about what had happened to his client, the judge leaned forward, and he looked all of 90, he was just 70, leaned out of his spectacles and said, "What do you want me to do?" The judge had no idea, because the first thing out of your mouth should be what you want the court to do. The court has jurisdiction to hear your case, make sure you're in the right court, and that it has the jurisdiction to deal with the justiciable matter that you bring before it. Make sure that the court has the power to do the thing that you want the court to do. Now, these are elemental, but quite often they're fundamental, and they're fundamental flaws where cases literally fall at the first hurdle, because the court says, well, we don't have power to make that order. The form of order you want is not available to your client. And that happens. But these are preliminary steps or preliminary questions for you to know and understand, am I in the right place, and can that judge do what I want that judge to do? And the rest of this address will focus on the interplay between oral and written argument. And written argument is very, very powerful. Pen is mightier than the sword, and an observation made earlier today about the judges reading your submissions. And this was during one of the meal breaks, where the first thing that the judge reads is your submission, your written outline, your written submission. The last thing that she reads before the judgment is written and settled and delivered will be your written submission. Right or wrong, regard will be had to your argument. So make it a good one. You've nurtured your argument, now let's present it. How do we present it in the proper way? Now it might be, it depends on, and I've tried not to be too specific, I want to be at a general level in this address, but the majority of cases are won on the papers. Some cases are completely lost on the papers. And in Australia, the High Court requires a party to make an application for special leave before they're entitled to run an appeal in the High Court. Your chances of a successful application for special leave are very low. In civil cases, it's something like 1 in 20 get to a hearing, let alone an appeal. and they're dismissed on the strength or rather weakness of your written outline or submissions for special leave. It's a brutal process. A small fraction of those, so this is the importance as I'll develop it, of making your argument, your written argument, really count. I'll explain how in a moment. But you might lose your argument, and the first thing you'll know about it is your email will have an attachment that says your application is refused, and you've never appeared before that court at all. If you're lucky, you get a hearing, and that's when you develop the rest of your argument to excite the court's interest as to why you should have leave to appeal. That's a peculiar event. Most times you get a chance to tell your story, and there will be an outcome from that in favour or against your client, as the case may be. At this point, I want to introduce a concept called discipline. And discipline sometimes is enforced, and in this way at least. The High Court in Australia has a very strict limit on the length of your submissions. 10 pages and not a word more. The font size, the spacing, etc. is dictated. And your case seeking special leave may have been a trial that lasted for weeks, with dozens of witnesses, thousands of documents, and you're reduced to telling all the facts of the case, what the errors of law were in the court below, the trial court, and then asking the court to intervene to overturn that decision. 10 pages. That's not a lot in some cases. So that's discipline of being able to tell your story concisely and precisely. So I want to spend a moment on the difference between an outline and submissions. And this will depend on the court and the level of the strata of the court you're in, as I say, with the specific rules that determine length of submissions and style of submissions and the like. But an outline is a roadmap. It's something that provides a guide to you as the advocate telling the story. I'm using one right now, and you have that outline. It's not a true submission. I'm telling a story based on that outline. Now, if I get lost at any point, I can look down and see from my notes or my outline where I'm going. And that's part of good practice. Right now, I'm addressing you. I'm looking at you. But I've got an note here, a footnote. We're addressing those things in the outline in a way that I'll extrapolate that as an advocate during the course of argument. And